I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Welcome back to Winning Isn't Easy. I'm here with my special guest, Marcus, my employment law buddy. So another question that I get all the time is, well, can my employer fire me because of my disability insurance claim?
Okay, well, that's a good question. And the answer isn't simple. I mean, let's be clear about what the question really is. Can my employer fire me solely because of my legitimate FMLA claim? The answer is absolutely no. You know, if the question is, can my employer fire me solely because I have a disability? The answer again is absolutely not. But we have to really frame the question, and we have to first figure out on the Americans with Disabilities Act side, are you, as I've talked about before, a qualified individual with a disability? So, you know, you have to seriously look at the question of whether or not you can still do the job even with an accommodation. And if you can't do the job even with an accommodation, then an employer typically is going to have the right to terminate under the Americans with Disabilities Act. Okay. Now, in terms of you know, the ADA, let's remember that accommodations are required. So we need to, when we look at this issue of what termination rights the employer has, what accommodations are they providing? Are they being stingy? Are they ignoring you? I would point out that employers have an obligation to engage in a serious discussion with you. It's called the interactive process. And if they're not doing that, they're in essence discriminating against you. One last point I would want to make is, I used the phrase solely because of a few minutes ago. You have to think about whether, you know, grounds are being asserted. So in other words, if an employee is stealing from the company and then and later goes on FMLA leave, the employer finds out during the leave that the employee was stealing from the company, it's still going to have the right to fire, because that termination in that scenario was not because of the person's taking FMLA leave or their serious health condition. It's because they were stealing from the company, at least if they can prove that. So, you know, it just depends on how you frame the question, whether or not your employer has the right to fire you.
So you and I both know that there are some ERISA disability insurance policies that actually require the employee to, or policyholder, to attempt to return to work in an accommodated position. What's the interaction, if any, between employment law and accommodations and an ERISA disability policy that says, you know, if your employer offers you accommodated work, you've got to attempt that?
Well, I have seen that, and I did see that when I was doing a lot of ERISA LTD. I mean, the policy is like a contract. You're going to have to do what the policy requires you to do, or you'll have a potential policy defense. You know, it's going to come back, I think, to what's reasonable under the circumstances. I know that's sort of a general answer, but that's, in this context, what I think is the right answer.
So often, of course, what will happen is that at some point in time, the employer is going to terminate the policyholder simply because their leave is expired, their FMLA is expired, or they just need to fill the position, or because the claim has been denied. What happens to the employee's group health insurance benefits and life insurance benefits?
Right. So as it relates to health insurance, employees typically have the right to continue their health coverage under COBRA. Now, COBRA is a federal law that applies to employers employing 20 or more employees. Most states, including Florida, have what's known as a mini COBRA provision, which applies to employers employing 2 to 19 employees. So it's basically this notion and obligation that employers have to provide some at least ground floor protection, but be sure to know that you're going to have to pay the premiums under COBRA. Okay. Now, as far as life insurance is concerned, you need to look at the policy, because the policy may provide for conversion rights, and it's very important if the conversion rights are contained in the life insurance policy, that you be informed they exist. All right, because conversion is this notion that you can, by paying the premium, convert the group life insurance policy to an individual policy.
So you and I both know that some policies will have a life waiver of premium, LWOP. And we sometimes get questions about, well, what happens to that LWOP when my employment ends and my group insurance ends? What happens there from an employment standpoint?
Well, when your employment ends, these policies typically will say that your coverage exists only as long as you're an employee. So when you cease becoming an employee, you cease becoming covered, typically.
Right. And of course, you and I both know that if an employee or policyholder is terminated and they have a short or long-term disability claim, they're not going to lose their short or long-term disability coverage because the claim arose at a time in which they were employed. So we don't want to leave anybody with the understanding that they would lose their short or long-term disability coverage if they were terminated.
That's absolutely right. Right. You look to when the disability, the claim, if you will, arose, and if it arose while employment was still in place, then you're absolutely right.
Marcus, what are the other questions that our listeners should be asking or thinking about that we haven't covered so far in this podcast?
I think one question to consider is, what can an employee do if he or she thinks that they are in fact a victim of discrimination? My advice to folks is consult with a lawyer. All right. There may be a number of things you should consider doing. You may well want to document what's going on. You may need to send emails or correspondence documenting your concerns and put them on notice, because one of the important aspects of employment law, which we just don't have time to talk about here, but I'll just kind of put it out there, is this notion of retaliation, that you should not be retaliated against for making a legitimate claim for discrimination. And retaliation is an entirely separate cause of action, to use lawyer speak, or basis to sue, to use a more lay sort of term.
So I, for example, have a case right now with a financial planner who is on his disability claim. He's on short-term disability, will be transitioning to long-term disability. And because he's not working his full-time hours or covering the number of cases he needs to cover, the employer is saying, we're going to change your commission and pay structure. In fact, we're going to claw back some bonuses that you took, that you were eligible for because of your disability claim. Now, you and I would agree, would we not, that that would be a potential retaliatory claim against the employer?
Yes, and we've talked a little bit about ERISA, and we talked a little bit about retaliation. Let's kind of marry the two. There's a clause, there's a section, if you will, under ERISA that prohibits retaliating against employees or coercing employees solely because they are, taking advantage of very employment benefits they've been afforded from the beginning.
And so obviously I've referred him to an employment lawyer in Texas where he lives, but those are some examples of retaliatory actions taken by an employer in conjunction with a disability claim. Can you think of any others that our clients should think about and recognize as potential retaliatory causes of action?
I'm going to tell you a recent development in the law is the notion of retaliatory hostile work environment. Now, this is a cutting edge concept, and it just really has sort of been developed over the past year in the 11th Circuit, the 11th Circuit being the federal appeals court that governs Florida. And that's this idea that if one is being belittled at work, one is getting harsh comments, if one is being told that they no longer have any kind of chance for a future in the company, that alone could be, under the most recent case law, a separate basis for suit.
So you and I, of course, have had cases where our clients have been working, they're disabled, they're doing the best they can. Now they're starting to get bad performance reviews, they're getting written up, and the environment's getting a little mean and nasty. Is that the kind of circumstance that this case law contemplates?
Right. It absolutely does contemplate that. And one of the strategies that may need to be employed in this situation is the filing of an EEOC charge. In a scenario where one is still working and perhaps on partial disability, I don't want to get too granular with the situation, but if one is being harassed, it's a situation where one might want to consider filing an EEOC charge with the EEOC, just so we're clear about this, the Equal Employment Opportunity Commission, alleging that one is being discriminated against on the basis of their disability. All right, so we have to look at each circumstance, but that again is part of the toolkit.
So how do you suggest that people find the right employment attorney for them? Because obviously you and I make recommendations to attorneys, for attorneys every day. But generally, what's the key to finding the right employment attorney for a case?
Well, one thing I would suggest folks do if they're looking for an employment lawyer is to go on the Florida Bar website and look specifically for an attorney board certified in labor and employment law. And the reason I'm suggesting that is because the process of becoming a board certified attorney is pretty arduous. You have to pass a written examination. You have to go through peer review. You have to show your experience in employment law over a span of at least 5 years. And so, by definition, you have to go through a gauntlet to even get that. And I don't mean to say here that there are bad or unqualified attorneys in the employment law realm who are not board certified, but it's just kind of an easy way to find attorneys who've, shown expertise and demonstrated through a test and the other things I talked about.
Well, I want to give a shout out to Marcus, because not only is he board certified, but he taught for many years in the board certification process for lawyers. Most employment lawyers will charge an upfront fee for a consultation. Is that correct?
It varies. Typically, yes, you will see some sort of consult. It sort of varies with the firm. I don't want to overgeneralize, but generally some sort of consultation fee is typical.
So how would you suggest that a person who has a disability insurance claim, who's thinking about consulting with an employment lawyer, go about having a concise consultation? In other words, you and I both know that the understanding the facts are very important. And people want to tell their story, but sometimes the story doesn't help us with the employment law question.
Well, I often tell folks, write up a synopsis. Give me an exec summary, right? Give me an exec summary with a timeline, and then give me a cast of characters. Tell me who's going to support your story and what exactly you're going to say, right? Because that format gets me to where I'm questions, right, and get more of a story rather than trying to pry the story out of you.
Great.
If that makes sense.
Obviously, you are my go-to employment lawyer in the Tampa Bay, Florida area, and I regularly send you cases. But how can people reach out to you if they want to ask you any questions about their employment law case as it relates to their disability claim?
Well, I'm going to give you two ways to reach us. The easy way is to call us at my office number, which is 727-535-4544. And again, I'll say that 727-535-4544. Or you can go to our website, which is www.haas, that's HAAS -Castillo, CASTILLO.com. And there you'll find some useful information, some ebooks, and some other, web features that may answer some basic questions for you, but at least will be a portal to So
in closing, any final comments you have to our audience who are obviously people who have disability insurance claims and are dealing with employment law issues?
Well, no, I think you covered the waterfront, but I would just say that, to those of you listening who may be on the fence about even, hiring a disability insurance lawyer, that you could not find anyone finer than Nancy. Nancy and I have had the chance to work together over a long period of time. So, said some kind things to me in this podcast, and I would just leap to say the same thing about you, that you are an accomplished litigator and do very well for your clients.
Well, thank you. And you and I are always a great team, and I enjoy working with you and your expertise that you bring to my clients. So thanks for this great information, Marcus, and taking the time to talk with us. If you like this podcast, consider liking our page, leaving a review, or sharing it with your family or friends. And remember, our podcast comes out weekly. So stay tuned for our next week's episode of Winning Isn't Easy. Thanks.